So there was a consent agreement in this case. It looked like you were before me once before
Yes.
in October, and you agreed to vacate the property on or before November 14th at 11:59 p.m. Is that correct?
Um, yes, or to work out of payments with them. Yes, I believe.
Okay, but that's not what this says. What this
Okay.
consent agreement says is that you agreed that that if you were still in the property, the plaintiff could apply for a writ of possession on November 14th.
Okay. Yes.
Okay. And it says that they dismissed any claims for money against you. Okay.
Um. th- okay.
That's what the order says. You agreed to that.
Okay.
All right. Because
Okay.
I have notes from that day when you were in court with me. And that was October 31st. Actually, it was on October 29th that you were in front of me. It was Attorney Young and I was the presiding judge that day.
Yes.
Um, and I swore you in under oath, correct?
Yes.
Okay, and I confirmed the terms of the agreement. Is that right?
Yes.
Okay. All right. And so then, did you vacate the property on November 14th or before then?
No, I did not.
Are you still in the property?
Yes.
Okay.
The judge reminds the tenant that he previously agreed in court to move out by November 14th. Everything sounds straightforward until the judge asks the key question: did he actually leave? The answer changes the tone of the entire hearing. The tenant calmly admits he never moved out and is still living in the property. Instantly, what looked like a settled agreement becomes a serious legal problem unfolding right in front of the court.
All right. And so you filed a letter to me. So the landlord applied for a writ of possession against you when you didn't move out. And I signed that. I think they filed it on November 21st. And I signed it on December 4th. All right. And then you sent me a letter and some documents. I didn't fully understand them, so we went back and forth a few times, but then you sent me a letter on December 16th. And you said you showed some pictures that you made a payment, a money order, it looks like. You just took a picture of it. I don't have an actual receipt for it. And it looks like you put it in a Dropbox. Is that correct?
Yes.
Okay. And how much did you pay?
I paid $25. I also included the messages in there in my motion. When I had text the person on how to make a payment towards them.
Okay, I saw
They
that.
had
So hold on
um
one second. Let,
yes,
let me go through. So you paid $25, and when did you pay that?
I paid that on November 14th.
Okay. And what was the monthly rent?
The monthly rent was 3,200.
Okay. And why did you pay $25?
Because when I had texted them and asked them about like how can I make payments, which I included in the message, she never specifically told me that I had to pay like the full amount. I asked them how can I make like payments, and that's what I'm making. That's what I had started to make.
Okay. And did they return that money to you?
They're saying that they did, but I've never received it or anything like that. All we have is proof of that I paid them, and not the proof of like the return.
All right. Okay. And so what are you wanting today from this court? You filed a motion to dismiss. So what are you asking?
This is where the situation takes an unexpected turn. The tenant explains that he tried to keep the tenancy active by making a payment to the landlord, but when the judge asks how much he paid, the answer raises eyebrows: just $25. The real shock comes seconds later when the monthly rent is revealed to be $3,200. The tenant argues that even a small payment counts as continuing the tenancy. Suddenly, the courtroom is dealing with a strange legal question. Can a tiny payment like that actually stop an eviction?
More.
I'm asking to dismiss because I did make a payment towards them, which would mean like our tenancy would be like ongoing.
Okay. All right. Mr. Young, do you have a response to that?
I do not have a response, but I would like to question my witness who can provide further detail about the situation.
Okay.
But I have no cross.
Oh, no cross. Okay. Mr. Miller, is there anything else you want me to know? I know I cut you off a minute ago and I apologize for that. What else do you want me to know?
I mean, nothing like that. I know that they're going to say that that they
Well, don't
returned
tell
it.
me what you think they're going to say. Let them say what they're going to say.
Okay.
Just you tell me what you want me to know from your side of the story.
Okay. Yes, I did. I did make a payment towards them. And um, they told me, not saying what they're going to say, but they told me that at first they told me that they did not receive the payment. Then the lawyer came back to me and told me that they did say that they received the payment, but they made a return for it. Also, the only way to make a payment to them for me was to come up to their office and drop the money order into their money into their mailbox, which I did send messages of them telling me how to make the money, I mean, to make the payments and everything like that as well. And so what I'm just looking for today is like a dismissal because I did make a payment towards them, and that shows that our tenancy is ongoing.
Okay. Hold on one second.
And if I may say one more thing, I never got an email or anything back from them saying that they returned anything, a call or anything like that. A receipt, a return letter, anything. Or I haven't even got the return back either.
Okay. And how long have you been living there?
I've been living here since last February.
So February of 2025.
Yes.
Okay. And when was the last time you paid rent?
In July, I believe.
Okay. And why didn't you pay rent for August through October?
When I had sent, well, I remember last time I had came, I was telling you about some issues, but I remember you said that that didn't have anything to do with this court. But when I had first moved into the place, and I submitted receipts for my first answer, when I first moved into this place, I had to do a lot of repairs myself. Even in the garage, I had to do a wiring repair, and if I had not did that repair, my home and also my things inside of it would have caught a fire. And that's what the electrician told me. They had a
Okay.
faulty
Okay. I
wire.
understand now. I got it.
They
Okay.
had a faulty wire in the garage, and I had to pay that out of my pocket, and nobody was responding to. And I had multiple things that I've had to pay out of my pocket, and nobody has responded to me about that. My dryer is still broke from when I first moved in.
Well, it sounds to me like when they dismissed the money claims against you, that was in some way a remediation for you for some of those repairs and conditions. I'm guessing. Okay. Just speculating. Okay. So, Mr. Young, do you have any cross?
I don't have a cross, Your Honor. No.
Okay. We're going to take a brief
I do want to have my witness question.
Of course. Yes.
Yeah,
I'm just
right.
going to take a quick break and
Okay.
take some of Miss Lewis's announcements, and then we'll come back to this position number one. Okay.
Thank you, Your Honor.
Thank you.
All right. So, Mr. Landon, let me ask you, so did you receive this $25 money order?
Hold on
Yes.
for 1 second. Can you just lay a foundation for him? Who is he and
Oh,
why
sure,
is
sure,
he
sure.
testifying?
Of course, of course.
Thanks.
So please introduce yourself to the court.
Hi, Your Honor. I'm the property manager and I represent DK Realty LLC in this case. And I'm aware of everything that's been going on with this process since the beginning.
Okay, thank you very much. And are you aware of this money order for $25 that was mentioned by Mr. Miller?
Yes, we received a money order on the week of the 14th until the 17th of November for $25 that we returned via mail because at that time the due amount was more than $11,000 and $25 does not cover the full amount. We sent a text message to him on October 30th at 8:20 a.m. saying that we were requesting the full payment to stop doing further actions or stop.
Now the landlord side steps in, and the numbers completely change the picture. The property manager confirms that the $25 money order did arrive, but immediately explains why it meant nothing to them. According to their records, the tenant wasn't just behind on one payment. He owed more than $11,000. They also testify that a message had already been sent clearly requesting full payment to stop the eviction process. With that, The tenant's argument begins to unravel, and the judge is left weighing whether the small payment holds any legal weight at all. If you found this breakdown interesting,
The eviction process that it was ongoing at that time, and we only received $25 for the payment.
Okay.
I'm sorry, what date did you say you sent that text
October
message?
2025 at
Oc-
8:20.
October 30th?
30th, yes.
October 30th. Okay. Okay, sorry,
All right.
go ahead.
And I think you may have answered it, but just for clarity, I just wanted to make sure. At any time, did you ever say to Mr. Miller that you would allow anything less than a full payment?
No, and it's clear that in the text message is saying that please advise that full payment is due immediately. To avoid any further actions, please submit your payment as soon as possible. We look forward to receive your full payment promptly. Is the statement.
Thank you. I have no further questions, Your Honor.
All right, Mr. Miller, do you have any questions for this witness?
Yes, just a few questions. You guys said that you sent me a message on what date?
It's October 30th, 2025 at 8:20 a.m.
Because I didn't get a message. Did I respond back to that message or?
You respond on October 31st, 2025 at 9:23 a.m.
And I said what then?
Completely different answer, nothing related with the payment that we request.
Oh, okay. That's it for the questions. I just didn't receive that message that he sent. They sent. Yeah, that's it for questions.
Okay. All right, Mr. Young, do you have any redirect?
No, Your Honor.
All right, you have any other witnesses?
No, Your Honor.
Okay. All right, Mr. Miller, just anything else that you want me to hear, know before we wrap this hearing up?
Yes, just one thing I know that they are saying that they sent messages out saying that they require the full payment. But again, like I've submitted evidence, texting them, and when I said in my evidence, I clearly state payments to them. And they text me back on how to make those. So I clearly stated payments. How do I make these payments with an S towards y'all? And they commented back to me how I make those payments.
Okay. Anything else?
No, that is it.
All right. So this text message that you submitted as part of your evidence, did you submit that to Mr. Young for review?
Yes, I did. I emailed it to him.
And you have that evidence, Mr. Young?
Yes, Your Honor. Is that the one?
It looks like it's four pages.
Oh, I just got two images.
Do you see the text
or,
message?
Sorry, one image. I see one that looks, well, it doesn't, I don't see a date on it. I see the time on the top is 4:41.
Oh, that I don't see.
Yeah, that's all that I see.
Okay. I don't. All right.
Okay.
Okay.
I'm sorry, I forgot to include the date. If you need me to,
Mr. Miller, I need you to turn on your camera, please.
I'm sorry. It went away when I went to the text messages. I didn't mean to turn them off.
Okay. All right. Is there anything else that you want me to know?
No.
All right, Mr. Young, do you have any final arguments?
I mean, final argument, the evidence that was presented, there's no dispute that $25 was dropped off in the drop box. But then the evidence today from my client is that it was returned, and that also just stands with reason. When there's an $11,000 balance, accepting $25 is not very likely, in most cases. And because of the testimony that money was returned with no intent to continue on with the tenancy, then we do ask that the motion be denied and the consent agreement stand.
All right, let me ask you this question. If they had accepted it, would that reinstate the tenancy, or would that go towards there was no money judgment awarded. So
Right.
If they had accepted it, would it reinstate tenancy?
Well, I'll tell you exactly what I tell all of my clients. including DK Realty here today, is that while a tenant is still in the property, whether a judgment was issued or not, that if money is accepted willingly, then they got to start the eviction process over, because of the question about whether they planned on, continuing with the tenancy or not. It gets a little murky there. That's why I tell every one of my clients, if you do not intend to continue with the tenancy, return the money immediately. And that is exactly what has happened here. So whether $25 would have reestablished a tenancy, it gets kind of murky, because that certainly isn't what's in the lease agreement. It's certainly not the past due balance. But I would say that if they had accepted it willingly, then there would be an argument there about the tenancy.
And Mr. Lodono, is it Lodono? Where did you mail the money order?
To the address of the house, and we return it to USPS on the 17th of November.
Why did you wait 2 days?
Normally we check the Dropbox 3 times per week. That it's Monday, Wednesday, and Friday, and that was the Friday of that week.
That was a weekend in between, Your Honor. I checked the calendar.
The 14th was a weekend?
The 14th was a Friday, and the 17th was the next business day.
Oh, okay. Oh, no, I'm looking at the wrong month. I'm looking at the wrong year, actually. I'm looking at the wrong month and the wrong year, so that's not helpful. Give me 1 second. Okay, I see.
And I know that because the 14th is my birthday.
Oh.
Happy belated birthday.
Okay. All right. Well, I'm going to take this case under advisement. I'm going to issue a written ruling. Mr. Miller, or to either party, whoever is the losing party, you will have the right to file an appeal, what we call a petition for review of my decision today. That will need to be filed within 7 days into either the state or superior court. I'm going to order that some portion of this judgment be paid into the registry of court in order to file the appeal, and forthcoming rent be paid as well, since Mr. Miller is still residing in the property. And so you said, Mr. Miller, that the monthly rent is $3,200.
Yes.
Okay. So today is the 7th. I'm going to order that if you do file an appeal, that you have to pay $3,200 into the registry of the court by 4:45 p.m. on, I'm going to say, I want to say the 15th, but let me look at a calendar and make sure. I'm going to say, Thursday, the 15th of January. And then every month thereafter, Mr. Dixon, I'm going to put you on mute because you're in a warehouse. Oops. Sorry. And then you're going to have to pay the rent on the 5th of the month, every month thereafter, until your petition for review is resolved. Okay?
Okay.
All right.
One thing, Your Honor, sorry. According to the list, the rent amount is $3,300, not $3,200.
I think that's what's on the original
Dispo.
dispo, $3,300. Yeah.
And I'm sorry if I missaid the
Do you agree that it's $3,300?
Yes.
Okay. All right. Okay, so I'm going to make it $3,300 since everyone's in agreement. All right. So that is the ruling of the court. Thank you all for being here, and you are excused from court.
And what's the ruling? I'm sorry. What is the?
I'm taking it under advisement, but I will issue a written ruling, and if I rule in the plaintiff's favor, then I will order you to pay rent into court. Okay. If not, if I rule in your favor, Mr. Miller, I will dismiss the dispossessory, and I suppose that the plaintiff will move forward and with another eviction case.
Okay.
All right. Good luck to you all. Thank you.
Good luck to you as well.
Thank you, Your Honor. And I believe that is my last case as
And
well.
when will I get this rent? I'm so sorry. How will I get this? Like in an email, or I just want to be on the lookout for it. However,
My order will go to the email address that you provided to my clerk. If
Okay.
you provided one today, otherwise it will go to the email address that you received your hearing notice for today.
Yes, ma'am. I'm sorry. I just wanted to get that clarified, so I just know where to be on the lookout for.
Yep, no problem.
Thank you so much. I'm done.
Thank you. Take care.
Okay.
All right. Bye-bye.
Thank you, Your Honor. Have a good day.
Thank you. You too.